Good afternoon, everyone. My name is Alexis Alvarez Bartholomew, and I am the Director of Statewide Training at Florida Legal Services. I'm very excited to be here with you today because we're talking about an important subject, and not only in this one webinar, but this webinar is part of a series. So I'm really excited to kick off the series that we're calling our Fair Housing Training Boot Camp, and really happy to have you all here to talk about the basics. So for those of you who are here, we're here to talk about basic fair housing rights, title being Back to the Basics. And before we get into introductions of our speakers and move into the content, I always want to give you housekeeping announcements so that we're all on the same page and you have the information that you need. So first and foremost, this is being recorded, and a copy of the recording will be sent to all of you who are here. That recording will be sent to you via Zoom, not from my email address, but I will pop my email into the chat. That way, if you don't see that email with the recording or it goes to your spam box, which things inevitably do, you can always reach out to me directly, and I can get you that recording that you need. Second piece of housekeeping announcement is your CLE credits. This is approved for CLE credit. And additionally, I mentioned earlier, this is part of a training series. I believe it's a 6-part training series, if I'm correct. I'm going to look over at my calendar here. Each of these sessions in this training series have their own CLE code, their own accreditation. And that's really exciting because although we want you to be a part of all of the sessions that we have, you can check out one, check out a different one if you're interested. You're not married to the entire series to get the CLE code, but you do have to attend the session to get the CLE code from that session. So this is approved for CLE credit, and I will be announcing that CLE code in the chat and out loud. And also that CLE code will come with that recording from that email from Zoom. So just keep your eyes peeled. And of course, you can always reach out to me if you don't get it. Third piece of housekeeping announcement, closed captions. Those are enabled for anybody that does need that extra accessibility to follow along. If you're not seeing those or you can't pull them up, email me or DM me separately once I'm done speaking, and I will do what I can to get you connected with that accessibility. Final piece of housekeeping announcements are questions and answers. This is a cool topic, and like I said, it's a series, so you're going to be seeing a lot of our speakers throughout this month and throughout next month as the series continues. So don't be shy, get to know us, put your questions into the chat or the Q&A function, and our preference for this series is to answer those questions in live time as we are moving forward through the materials. So if a question comes up, pop it in. We'll address it right then and there. And so I think that's enough of the housekeeping. I'll move into the introductions of who we have here today. And I think I said this last year, I get so excited when I get to do trainings with my colleagues at FLS. For those of you who joined us for last year's training series on fair housing, we have Joe Cordova back with us. And then we also have with us Pia Molina, who is going to be taking the series from here with Joe. So a little bit about Joe. He spent the first 2 years of his legal career as an Equal Justice Works Fellow, practicing community lawyering for immigrant families. He has since transitioned such effort into housing discrimination and enforcement and outreach, where he manages Florida Legal Services Fair Housing Initiative projects. Joe has a bachelor's degree from DePaul University and an MA from the University of Colorado in Public Policy, and a JD from the University of Florida, Levin College of Law. He has over a decade's experience working with vulnerable populations, performing community development services, and was recognized by the Levin College of Law with the 2018 Helen Gibble Bleachman Bleckman, right? Memorial Community Service Award. Sorry about that, Joe. And we also have with us Pia Molina. Pia is a 2-time graduate of the University of Florida, earning her bachelor's in anthropology and her master's degree in Latin American studies. Since finishing school, Pia has been part of various nonprofit efforts in the local Gainesville area, ranging from children's advocacy to fair housing. She continues to follow her passion for social justice efforts through community-led projects and volunteering. So I'm so happy to be here, honored to share this platform with you, honored to be your colleague, and enough of it from me. I will turn it over to you, Joe, to kick us off and get into the substance of what we're here to learn about today.
Perfect. Thank you so much for the introduction, and thank you so much, Alexis, for hosting us. Just as excited as you are to work with us, we are to work with you, so this is fun for everybody. I'm just going to say a quick note, then I'm going to pass it on to Pia. So we're doing our Fair Housing Boot Camp series. Today we're going to do the basics of the Fair Housing Act, kind of a 101 kind of tour of the Fair Housing Act. And then just to let you guys know, over the course of the next 6 weeks, we will also be covering topics such as disability accommodations, modifications, emotional support animals. We'll be talking about updates to the Fair Housing Enforcement, including LGBTQ plus rights. We will be discussing VAWA and protections for DV survivors, families with children, and how to engage fair housing work in immigrant communities. So those will be some of the upcoming topics. So today with our Basics 101, we might be covering some of those here and there, but we'll have much more depth later on in the upcoming weeks. So with that, I'm going to pass it on to my colleague Pia, and she's going to take the first 10, 15 minutes, and then we'll kind of pass the mic back and forth. So Pia, it's all yours.
Hi, sorry, I'm not gonna have my video on just for connectivity purposes, but I'm here. So today we're talking about the Fair Housing Act, specifically the Federal Fair Housing Act, emphasis on the federal since each locality and city, county might have their own Fair Housing Act that they can also enforce. Our work focuses on the federal, so sort of like the floor of the protections, which includes 7 protected classes: race, color, religion, national origins, sex, disability, and familial status. Each one is, everyone has these protected classes. It's not necessarily a minority status by any means. It is just if they are used against you in any housing related transaction. Yeah, I think the next slide kind of talks about them further. Yeah, there you go. So race in the Act is defined as heritage, bloodline, and identity. So kind of where you and your family are from. Color is defined as something different, and that kind of just talks about the literal color of your skin and features. I think they're both used together often. Sex is a big one in that it includes both gender identity and things like sexual harassment and domestic violence, but also is enforced to include sexual orientation and gender identity. Under in the sexual harassment is both quid pro quo, talking about when getting something for something else, sort of deal, and hostile environment where the person might not feel safe living in their home or in their home environment because of the harassment. Then we have national origin, when that counts as you or where your family is from. Both are protected. Speaking a different language can also be seen as a protection under national origin. Disability is any disability is considered a physical or mental disability, anything that affects a major life activity. Major life activity is defined as anything necessary for life, which is like talking, walking, any sort of big activity is a major life activity in this case. Religion is practicing a religion or your spirituality. It also includes not practicing a religion. And families with children is anyone living with children, minors under 18. It includes pregnant women and foster parents or grandparents who might be the legal guardians or have the custody of the children living in the household. So these are some of the additional protections that I had mentioned that each place might have. I live in Alachua County, and I think Joe has mentioned that Alachua County has some of the more protections in the state of Florida. So for example, sexual orientation and gender identity is specifically outlined under Alachua County, even though it is enforced under the Federal Act, it's not specifically written into the law. Lawful source of income is also one of the inclusions, and citizenship status. age. All of these are, I guess, the extra additional protections. And then in the city of Gainesville, specifically in Alachua County, they also have their own protections, which include some of the ones that Alachua County gives as well. And so these are things that are protected, but under these local fair housing laws and not necessarily under the one that we work under, which is the Federal Fair Housing Act. So it's anything in the act is defined as a housing transaction. So that is the rent, sales, home mortgage, lending, appraisals, homeowners insurance are all considered under housing transaction. I think a lot of the time when I'm doing these presentations, people say like, I don't rent, so I'm okay. But it can happen in the other end when you're trying to sell a home or you're trying to get appraisal for your home. That's also a common place where fair housing violations can occur. Yeah.
One thing I would add there, maybe we need to add this bullet point because it's coming up more and more, is homeowners associations and condo associations. Those are going to be part of. So you might consider yourself, I'm an owner and I own my own home, but I own a home in an HOA. Well, that HOA is covered. And I think that the next slide might talk about that as well.
Yeah, and so who must follow these rules? I kind of learned this as anyone who can deny you housing. And so here we have a long list of those people, including landlords, real estate agents, lenders, insurance companies, homeowners associations, as Joe had mentioned, housing developers. Anyone who uses media to advertise their home is now under the Fair Housing Act and can be seen as violating it, even if they are part of some of the exceptions. It also includes anyone who might work for these people, including like maintenance workers or someone who's contracted by a larger, property owner or property management company. And then at the very bottom, it has tenant/neighbors as a question mark because tenant-on-tenant harassment does occur. However, the tenant is not necessarily responsible for that under the Fair Housing Act. If you as a tenant make it known to your landlord or to the property manager that you are being harassed or feel a certain discrimination from your neighbor, the person kind of responsible for denying you housing or who can deny you housing is the one who has to kind of take care of the situation. So it shouldn't go unmanaged or ignored, but it won't be the tenant necessarily who's taking care of that. It'll be the landlord or the property manager in this case. You are muted, Joe.
Yeah. All right. I'll take the next few slides. We're going to now talk about kind of the actual Fair Housing Act itself, in particular sections of the Fair Housing Act that can be violated. We'll look at them a little bit one at a time and kind of I'll give you some examples of how and when we see these particular parts of the law violated. So Section 804A, which is U.S. Code 3604A, anyone who refuses to sell or rent, negotiate, deny, or make available housing. And remember, this is based on one of those protected classes. So I'm refusing to sell or rent a home or an apartment because of your race, color, religion, gender, and so on and so forth. This includes negotiate or deny or make available housing. So this is kind of this is the initial one. But this one, at least in my work, my experience, doesn't come up as often. A lot of times because most of the calls we get are people who are current tenants and we're looking for discriminatory treatment as an existing tenant. Although the act definitely covers, pre-tenancy while you're looking for a place to live. If it was denied you home, you're being denied housing. 804B is what we do see a lot, discrimination in the terms and conditions of housing. This can often be tricky to find, but when you find it and you're able to clarify it, not only for the tenant, but for your own, complaints that you're filing, these ones can be, I guess, some of the more creative cases that come forward. So this would be, let's say, for example, you have an emotional support animal. and your property manager says, absolutely, we love emotional support animals, no problem, but one strike and he's out. Well, that's a different term and condition. If everyone else has a one strike and you're out rule, then I guess that's not discrimination. But if you're given a one strike and you're out rule, that is fine. I'll give you an example that came to me recently, and I was trying to walk the inquirer through how the Fair Housing Act would play into this. This person came to me and said, I have a cat. My neighbor has a dog. As a cat owner, I'm given lots of different terms and conditions. My cat can only do this, my cat can only do that, whereas my neighbor who has a dog is allowed to do so many different things. I feel that that's discrimination. And my response was, that's true. That does sound like discrimination. Unfortunately, it doesn't cross the threshold of a Fair Housing Act violation because cat owner or what type of pet you own is not a protected class. It's race, color, religion, family status, disability. But it doesn't say cat owner or dog owner is a protected class. So I had to go back and say, well, if your cat is given different terms and conditions than your neighbor with the dog, what else is it about you as a tenant that might be given different terms and conditions? So let's take the focus off of the cat and the dog and put the focus on the tenant themselves. Are you of a different race, color, religion, gender than the dog owner? Do you feel that the landlord is giving the dog owner better treatment because of who they are? Not because of them being a dog owner and you being a cat owner, but because of their characteristics and their belonging to a certain protected class that is different from yours. That's what we're looking for under the Fair Housing Act, okay? So I kind of had to walk this client through. I apologize that the cat owners of the world might be getting different terms and conditions, but that's not the protected class we're looking for. So a lot of times these stories will come to us with some unique, we walked through the door with a unique story, but it's the discussion that helped us understand how those different terms and conditions are being revealed. As far as Section 804C, this is the big one, and I'll explain why here in a second, but 804C is any discriminatory statement and advertising. So any public statement that is made that is discriminatory. So I often remind housing providers when we give this presentation to apartment community managers, property managers, landlords, is that you might be violating the Fair Housing Act while someone you've never met before is checking apartment listings at 3 in the morning at home because they couldn't sleep. And you suddenly are on the receiving end of a complaint saying, Mr. Johnson is filing a complaint against you. Well, we've never even met Mr. Johnson. We don't even know who they are. How can we discriminate against them? It's because your advertising is discriminatory. And it's on Facebook, it's on the internet, it's on other social media. Maybe they saw a billboard. Advertising has a lot of high scrutiny. A lot of eyes are paying attention to advertising. If you drive by a billboard that says, we've all driven along Florida's many highways with lots of billboards advertising 55 and older communities. And it shows people loving life, playing tennis and going swimming and walking along the beach. If it's only white people in those billboards, that's discrimination in advertising, okay? We might get to a point where if it's only male, female couples in the billboards, maybe that's going to be considered discrimination advertising. Your advertising must promote the idea that all are welcome here. And if it's not, then that might be something we're able to say you are discriminating in advertising, violation 804C. In addition to advertising, statements. This is something we always ask clients for. A lot of times people bring us their stories and say, I feel like I'm being discriminated against. And we say, how? And they end up describing a story where they're being mistreated, but it's not necessarily discrimination. We always ask the question, do they treat you poorly and nobody else, or do they treat everybody poorly? And a lot of times they say, oh, my landlord's terrible. They treat everyone poorly. And we kind of roll our eyes and say, that's not a violation of the Fair Housing Act. That's equal opportunity discrimination. If they're treating everybody poorly, that's not discrimination. What we're looking for is that differential treatment. So a lot of times we have to go to the next question, which is, has your landlord ever said anything out loud to you in a text and email that was discriminatory? Even if it's under their breath, even if it's in passing. But if they say something like, oh, I'm so sick of people like you, or you people, or I wish we never would have rented to your kind of people, now we have a discriminatory statement, okay? Or I had a case recently where the spouse said, my landlord will only speak to my husband because he's a man and I'm a woman. Okay, how was that portrayed to you? Well, he simply said, I'd like to speak to your husband instead of you. Okay, that might be a discriminatory statement. Okay, we're looking for those clear examples of when something was verbalized or communicated in the form of a statement that was preferring or limiting opportunity for a particular protected class. So that 804C is a big one. And then 804D is somewhat similar to 804A, but it's very specific to the misrepresentation of available housing. So the story goes, hi, I see on Craigslist you have a 3-bedroom home to rent. I would love to come by and see it. I'll be there at 2 o'clock. And when you show up at 2 o'clock, the landlord standing on the porch sees you pull up. You have kids in the back seat. And when you get out to shake his hand, suddenly he says, you know what? I just had somebody call ahead of you. It looks like this place is no longer for rent. Wow, suddenly it's not available because you saw that I have kids, or you saw the color of my skin, or you heard that I speak English with possibly an accent you're not familiar with. So you misrepresented that it's no longer available. And a lot of times this story can get tricky because the sudden unavailability is a pretext for that discriminatory treatment. So even though a lot of respondent parties can show a paper trail of, look, I ended up renting it to somebody else, that's fine, but you did it once you knew that our client was of a particular protected class. And then 804F, so 804A, B, C, and D, they all talk about the 7 protected classes without including disability, but 804F includes everything disability. And this is where we get into the world of reasonable accommodations and modifications. We're not going to go into the details in this training, but we have that coming up in one of our upcoming presentations that's all about reasonable accommodations and modifications. But in addition to discriminating against somebody simply because they have a disability and you're just not going to rent to them because of that, once you are a tenant or even as an applicant, if you request an accommodation, which is a change to a particular policy, pattern, or practice, or you request a modification, which is an actual physical or structural change because of your disability, as long as it's met with enough information to prove that you need it, and we'll explain, in the upcoming presentation what that all includes, landlords needs to approve it. And certain ways that it can be denied is simply not responding. That's become the trendy way to deny someone a reasonable accommodation, is to just simply let the request go unanswered. That is now considered by courts a constructive denial of an accommodation request. So 804F is where you're going to find all of the disability-based protections. And then 818, it's not necessarily a catch-all, but I've learned in my work, and whenever I file a complaint, 818 seems to sneak in there. And that's where you're going to talk about the interference, coercion, intimidation, and if there's any story of retaliation that comes up in your fair housing a story or fact pattern, that's going to be 818, as far as the story would simply go, I filed a complaint, or no, I'm sorry, I requested a reasonable accommodation, and rather than approving it, you just non-renewed my lease. All right, that's probably going to be a version of retaliating against somebody for exercising a right that they have, and you can throw that under the 818 there. So as far as who is responsible, let's just ask this really quick. So a tenant complains to the property manager that another tenant is harassing her because her kids behave differently. Who's on the hook here? Feel free to jump in the chat box or whatever. Who's on the hook for being potentially violating the Fair Housing Act if the right thing is not done here? A tenant complains to the property manager that another tenant is harassing her because her kids behave differently. Who's violating the Fair Housing Act? We see tenant. Okay. So the correct answer is the tenant is creating the scene, but it's the property manager who's violating the Fair Housing Act if they don't do anything, okay? Because remember, a fellow tenant does not have the power to deny or limit somebody's housing. They might make it hard to live there, but they're not the other person on the other side of that lease or that contract. They don't have power in that situation. The property manager does. So if you complain to a property manager that my tenant is harassing me because of my kids, which means we have that nexus with a protected class, families with children. If the property manager simply rolls their eyes and says, oh, that's between you guys figure it out, that's a violation of the Fair Housing Act, and the respondent in that one is the property manager. You can't file a complaint against a fellow tenant. You might be able to add them in, but as far as the actual violating party, that's going to be the property manager, because they have a duty to mitigate or make right the harassing behavior of the tenant. So let's talk about any exceptions to the Fair Housing Act. And this is an important one to remember. Anytime a story comes my way, I have to hurry and hop on the property appraiser's website to make sure that the discriminating party is someone who actually can violate. Real quick, there's a question. How is the manager able to determine if it's discriminatory between the two parties outside of a complaint? I love that question. So when we give this presentation to housing providers, we remind them that their job is to be the property manager or the leasing agent. They're not judges. So it's not listen to the, he said, she said, and make a decision and evict. What the landlord's responsibility is to mitigate that situation. You go to the other party, the harassing party, and say, we hear from another tenant that you have been behaving in a harassing behavior or bullying another tenant. Tell me, what we need to have happen in this community is that these things don't happen. You're basically trying to stop the behavior from happening. And we always tell housing providers, keep a paper trail. We contacted both parties on this day. We set up a tenant meeting. We set up a meeting between the two parties. We talked to each one individually. We basically extended ourselves to mitigate what's happening in the name of putting an end to it. If the behavior is so egregious and there's enough witnesses that attest to, yes, it's not just harassment, it's bullying, and it's really bad, absolutely, you can move forward and evict that party, as long as you kind of have that paper trail that shows why. Because remember, landlords have lease and contract agreements with all of their tenants. You can't just simply take one tenant's word over another and then therefore end a contract with somebody else. That other party is going to say that's a breach of contract. You didn't have a right to do that. You didn't have enough evidence or cause for doing such things. So we always remind housing providers, don't be quick to evict, but you can't just sit on it. You can't just say you guys need to figure this out between the two of you. You have to play a role in mitigating that situation. So I hope that answers the question. Yeah, you got to get in the middle of it. That's the idea. So are there any exceptions? Yes. Okay, so if you have an owner, okay, this is what's often referred to as the Mrs. Murphy law. If you are an owner or a Mrs. Murphy exemption, I'm sorry, the Mrs. Murphy exemption is the idea that Mrs. Murphy is an older woman, her husband just passed away, and now she lives in a home all by herself and she's lonely. So she decides she's going to rent out a few of the rooms to a roommate. She's allowed to discriminate in who she wants to have live with her, but she cannot state it out loud. Remember that 804C, that applies to everybody. So Mrs. Murphy can't post an advertisement on Facebook or Craigslist that says, I'm looking to rent one of my rooms, but I prefer a female roommate. No, that's a public statement. You can't say that. You can say, I have a room to rent, looking for applicants. And then in Mrs. Murphy's mind, if she keeps it to herself, she can decide, I prefer to live with a woman. But you can't publicly state, these are the protected classes I would enjoy living with over the rest. Similarly, if you are a landlord, maybe your spouse, or you and your cousin, a friend of yours, you guys invest in another home that you're going to use as a rental. If you have less than three or fewer of those homes, you are exempt from the Fair Housing Act. However, same rule applies for that 804C, public statements and advertising. And also add to this, if you use a broker or a property management team, you are no longer exempt from the Fair Housing Act. So even if you only have one unit or one home that you rent out, but maybe you're a snowbird, okay? So you live in another state and you rent out a home that you own in Florida. If you're using a property management company to oversee that property, you are no longer exempt from the Fair Housing Act. And this can get a little tricky here and there. If, let's say I'm a snowbird, I live in Minnesota, and I rent out a home in Florida, and I have my sister oversee the property while I'm gone, that might qualify as a broker. Okay, so that would be something to be aware of and be careful of, because I'm using another party to oversee and manage my home. I may no longer fall within the exceptions of the Fair Housing Act. And then finally, communities that qualify for housing for older persons are allowed to exclude families with children under the age of 18. This can get really tricky. Number one, you actually have to be a certified 55 and older, 60 and older community. You can't just be a neighborhood that happens to have a lot of retirees in it and everybody pinky promises to keep it that way. That's not a certified 55 and older community. You actually have to be certified. Places where this can get tricky, and this comes up a lot of grandparents or a lot of 55 and older families will have maybe an adult child with a developmental disability or something like that. So they're 18, 19, 20 years old, maybe 30 years old, but they're under 55. And they're trying to get an exception for the community rules to make sure that that person can live with them. And people bring that to me and say, isn't that disability-based discrimination? The answer on the basics is no, not yet. Because the 55 and older community, they're not saying no because they have a disability. They're saying no because they're below the age of 55. Now, if you find out later on that some of your neighbors have a 30-year-old adult son living with them who does not have a disability, but your 30-year-old adult son did get denied who does have a disability, now we might have disability-based discrimination because you allowed one family to have an exception within your community rules, but not the other. And the difference between the two families was one had a disability and one did not. So remember, a lot of times people will try to say it's not fair. They're not letting my family move into this 55 and older community. And we think it's because of a disability or because of this. It's fine as long as they're saying no solely because someone in the household is under 55. Now, real quick, there's a lot of confusion. Florida has what's referred to as the 80-20 rule. 80-20 means that if you're a 55 and older community, you are allowed to have 80% of the homes in your community 55 and older, and you're allowed to have 20% designated as not 55 and older, and you would still qualify as a 55 plus. A lot of words and think that the 80-20 rule mandates 20% of the homes must be set aside for families with people under the age of 55. It's not that, it's the reverse. You can keep your status as a 55 and older community and still allow for 20% of your homes to have families under 55, but you don't have to. It's not a must, okay? And then the other exception, we don't have a bullet point here, but there are religious organizations that reserve housing specific to religious I'm imagining, the Catholic Church doesn't have to allow non-Catholic priests in there in the housing behind the church, and then versions of that throughout other religions and stuff like that. As long as the reason why you're denying housing is because they're not members of that particular church, then that would be fine if it's a religious exempted organization. All right, so those are the exceptions. So we've talked a little bit about this so far, but I really want to hammer it home because this is one of the biggest issues we see when we get people calling us. Discrimination under the Fair Housing Act, it must have a nexus with that protected class, okay? When we say nexus, we're talking about that because of factor. So I refuse to rent to a family with children because they have children, not I refuse to rent to a family and they have children. You're not immune just because you're a member of a protected class. Because like Pia said perfectly at the beginning, we're all members of every protected class. I am a race, I am a color, I am a gender, I am a religion, I am a national origin, I'm all of them. If what I am is being used against me, that's a violation of the Fair Housing Act. So I've had a lot of people call me and say, isn't this unfair that they're doing this to this person and they have a disability? And I'll say, yeah, that raises the stakes of my emotional, my heart going out to your story. And having a disability is not a violation of the Fair Housing Act. You're not immune. It's because of. So refusing to rent to a person from another country because they're from another country. This can get tricky as well. And we'll talk about this under the immigrant presentation in a few weeks. But national origin discrimination, remember, we're talking about national origin. Now, this can also be assumptive national origin. So if I am a landlord or a property manager and someone is speaking Spanish in the application or during the tour, and I'd suddenly say, you know what, it's no longer available. That person doesn't have to actually be from another country. Their family could be. Maybe their ancestry is. Maybe they just like speaking Spanish and they're studying for a Spanish test in college and they're practicing. I have no idea why they're speaking Spanish, but I'm assuming it's based on them being from another country. That's going to qualify as fair housing discrimination because it's the perceived protected class. This also includes, and this comes up a lot, I feel I'm discriminated against for national origin-based discrimination because I speak Spanish. I'm Puerto Rican. I'm a US citizen. I'm Puerto Rican. But the landlord still denied you based on some sort of assumption that you are not from the United States or you're from a different country that they prefer not to rent to or something like that. So national origin discrimination can be very wide. And then when we do the immigrant training, we'll go into further details there. I want to jump to the no nexus because these things do come up. So let's say a family with children can still be evicted for failure to pay rent. I did have a couple people recently, and this does come up a few times throughout the year, where the accommodation they're asking for is to not pay rent. Any of you that practice landlord-tenant law, it'd be a whole lot easier if a landlord was forced to allow for an accommodation to simply not pay rent. No, you can create a stipulation agreement with your landlord to maybe be late or to make up previous payments of, I'm late 3 months, but it's not an accommodation because it's not reasonable. When we talk about accommodations, we're talking about a reasonable accommodation, not to mention accommodations under the Fair Housing Act only qualify under disability accommodations. So a family with children who's struggling can't go to the landlord and say, can I simply not pay rent or can I be late? Now, let's say the landlord says no to the family with children. Sorry, no exceptions. You got to pay rent by Friday or I'm giving you that 3-day notice. And you overhear your neighbor who asks for the same thing and the landlord says, fine, no problem. And your neighbor doesn't have families or doesn't have children. Okay, now we have differential treatment. Okay, what we're looking for is who is allowed to do something and who is not allowed to do something. But it can't just be a standalone story of, can you believe my landlord's making me pay rent? I sure can because you signed a lease and that's what the lease is for. If the story says, can you believe they're making me pay rent, but they're letting everybody else skip a month? Okay, now we have discrimination, okay? A smoker can still be warned for not complying with non-smoking policy. I like this little quiz. I'm interested. Please, I hope people jump in the chat room for me real quick. I'm going to ask this question. What about medicinal marijuana? Medicinal marijuana. Does a landlord have to allow, if you say, I have a card, certified medicinal marijuana, I have a disability, I'm requesting an accommodation for my your non-smoking policy. Does a landlord have to say yes? I'm going to do the awkward thing where I sit here for a little bit and make sure people say, all right, we have a no in the chat room. Anyone want to challenge the no, or are we going to let the no stand? I would say the landlord can say no. Any others? All right. So does the landlord have to? The correct answer is no, they do not have to. The treatment for disability slightly. Okay. If I make an accommodation request, I would like to get around your no smoking policy because I have a disability and I have a medicinal marijuana card, so I would like to consume marijuana on the premises. The landlord in that particular very specific situation is allowed to say yes or no to that accommodation. And the reason is because marijuana is still illegal at the federal level. So it's an unreasonable request to force the landlord to violate federal law. Now, in the state, it might be okay, and the landlord might be fine with it because they're probably not going to get in trouble or prosecuted or anything like that. Um, if you say, I don't feel comfortable with it because I don't want to be on the hook for violating federal law, that is a reasonable denial. Okay. Um, but if they say something like, well, I'm going to allow it, but I don't want you to smoke marijuana, maybe you come up with a interactive process to mitigate. Maybe it's in the form of edibles or something like that. So if the landlord chooses to say yes, they can still say, but we're going to make you abide by the no smoking policy, but we're going to allow for the marijuana on the premises. But for the most part, it is unreasonable to ask a landlord to violate federal law or to, mandate that they have to. So that one's a tricky one, and it does come up. We have a question here. Where does differential treatment move to discriminatory when maybe the reason they're not getting an exception is because they're constantly late with renting or constantly causing problems with other neighbors? Is there discretion or automatically discriminatory? Great question. Like, if the landlord has a legitimate reason for an eviction or something like that, like this person is violating the lease, they are a nuisance, they are late on rent, I can point to something that says, you have breached your contract with me, then protected class is not going to save the day. But if it's reverse and I am always discriminatory against you because of your race, color, religion, national origin. I've always picked on you. I've always harassed you. And the very first time you are late on rent for 1 day and I serve you with a 3-day notice, there's a good chance that that is a pretext for the discrimination. In that scenario, we would ask them, do you know any other neighbors that were 1 day late on rent? And did they also receive a 3-day notice right away? If the answer is no, he only did it for me, then chances are he was waiting for you to mess up so he could lawfully evict you. When we all know he was discriminating against you the whole time, waiting for you to slip up. We're really looking for that differential treatment. And I like this question because it reminds me, in doing fair housing case work, the timeline is so important, whether it's requesting an accommodation or who said what when. It's really hard to file complaints or successful complaints when we don't have a proper timeline of who said what or who did what, when, and where. What we're really trying to establish is that the behavior of the landlord began to be differential on this date in this fashion. If it's just a story of I get a funny feeling anytime I'm around my landlord, that's not enough to get across the threshold. So I like this question because it gives the idea of we're looking for examples with a timestamp. If the examples are my landlord uses this language around me, he treats the other person better than me, and I have actual examples and instances of it, our complaint is that much stronger. If it's my landlord evicted me and I was a month late on the rent, but he's also mean to me, we probably don't have it because you breached the lease by being late on rent by a full month. Does that kind of answer the question? I'm not sure if I danced around the question or actually got to the answer there. Okay, perfect. Okay, yeah, so that's kind of what that nexus we're looking at. You can have poor treatment and it not be a violation of the Fair Housing Act. In fact, a lot of the people that call us, we do have to respond by saying it looks like you just have a bad landlord. And it's not discriminatory though. But we do always ask the questions to try to find that nexus. Which leads us to this next slide, and it looks like we're getting close to time, so I'll do my best to get through this one pretty quickly. Disparate impact, this comes up a lot. Landlords, property managers, HOAs, they might have rules that appear neutral on their face, but they have a negative impact on specific classes. This example, we're talking about DV survivors, okay? So let's say you're a landlord or you're a leasing agency and you have a rule that says anyone with a prior eviction cannot live here. And that's everybody, men, women, race, color, doesn't matter. If you have a prior eviction on your record, you cannot live here. Well, statistically speaking, women have higher rates of eviction because they're often evicted for being on the receiving end of domestic violence. Called the police, 911. My boyfriend was over last night. We had an event. I called 911 for my safety. When the boyfriend left, I got evicted. Okay, statistically speaking, the DV survivor is going to be a woman more often than it is a man. So if I'm going to have a rule that says anyone with a prior eviction can't live here, the rule is fine. The impact is discriminatory because at the end of the year, I'm going to end up denying housing to more women than I am men. So women are disproportionately affected more than men by that zero tolerance crime policy or the zero previous eviction policy. So housing providers are expected to make exceptions to those policies, to make case-by-case determinations based on why someone was evicted. I always remind housing providers, if you have blanket policies, you're probably going to be violating the fair housing one of these days. You have to move your policies to case by case because people have stories, and if you don't listen to those stories, you're going to violate rules of disparate impact. It's almost inevitable. A lot of people come to us with fair housing inquiries and they don't result in fair housing violations, but that doesn't mean a law wasn't broken. Maybe the Civil Rights Act, a lot of local county ordinances, a lot of state landlord-tenant laws might overlap and intertwine with the Fair Housing Act, although they are very different. And then a lot of times consumer protection laws can come into play when it comes to potential violations of housing that might not cross the threshold of fair housing. And then finally, if somebody is an aggrieved party under the Fair Housing Act, they can file a complaint with the Department of Housing and Urban Development. That's something that our office does quite a bit of. We help people, we file complaints on their behalf, and then we help them navigate the administrative process. Under the Fair Housing Act, you have 1 year to file an administrative complaint through HUD. It's the 903 complaint form. It can be found online. That the most important part of the 903 complaint is the narrative, where the narrative kind of answers the who, what, where, why, when of the situation, the fact pattern, and the story. What usually happens is you file it with HUD, and then HUD will kick it down to the local FAP, which is kind of the Fair Housing Enforcement Body. They're grant funded under HUD. In the state of Florida, we have a statewide FAP, which is the Florida Commission on Human Relations. They take the statewide cases. And then locally, we do have FAPs in Broward County, City of Orlando, Jacksonville, Palm Beach, Pinellas, and the city of Tampa. So if you can file complaints directly to the Florida Commission on Human Relations, you can file complaints directly to any one of those county or city offices, and you can file complaints all the way at the highest level with HUD, but HUD might still send it back down the ladder to have more of a local enforcement. When you file those complaints, it triggers an investigation. The investigator will interview the complainant, they will interview the respondent party, and they will try to get to the bottom of whether or not discrimination occurred. If the investigator turns up that they say, yes, our investigation, we do feel that there was discrimination, you are welcome to keep going up the administrative ladder to an administrative court to have that investigation or that cause determination be adjudicated with an administrative court. And maybe there will be some damages coming your way. Usually there's going to be some sort of punitive result that the housing provider has to go through fair housing training, change their policies and practices and stuff like that. You are also welcome to take that completed investigation and cause determination and say, thank you very much, but now I'm going to sue them in a civil court of law. And I have that smoking gun evidence, which is a completed investigation that said there was discrimination. The reason why that might be a better opportunity for your client is that in Florida, you cannot receive non-quantifiable damages without a jury. And because administrative courts don't have a jury, those damages seem to be pretty low. Civil court, that's where you might get that quote unquote payday for your client if it's such an egregious violation of the Fair Housing Act. Complaints, you have 1 year to file from the last occurrence. Lawsuits, you do have 2 years to file in a civil court, and that depends on the jurisdiction. But what we always recommend, as far as enforcement goes, contact your local FIP, which is what we are. We are grant funded by HUD to assist people through this complaint process, to potentially file lawsuits on their behalf. We're the legal advocates to help people as they're experiencing these complaints. Obviously, any attorney can do it and people can do it on their own, but it makes a lot of sense to have someone assist you in that navigation process. So that's what we have today. We have time for questions. The goal is 50 minutes and we hit it perfectly. Look at that. So what questions do y'all have?
Yeah, folks, feel free to continue to drop your questions into the chat or the Q&A. We have until 1 o'clock on this platform and this space. In the meantime, I'll definitely give some, additional housekeeping announcements about the CLE code and things like that. But before I do that, I do want to say, because we have, about 10 minutes left, if you do want to pose a question verbally, if it's too much for you to type and you prefer to pose it verbally, what I can do is if you raise your hand, and I'll be able to see that on the participant list, and I can unmute you to pose your question, and I'll mute you afterwards just to prevent any sort of, disruption. But if you do have a question and you prefer to say it verbally, just raise your hand, and I will take you off mute. And so something came in through the chat, Joe. I'm going to put the CLE code in if you want to look at that, and then I'll bounce back in.
Sure. I'll read it while you're doing that. It says, what is sufficient evidence to prove discrimination based on disability? Okay, so disability has a couple ways you can discriminate. Number one is just I'm denying you housing or giving you different terms and conditions because I discriminate against people with disabilities. For whatever reason, people with disabilities, they're a class of people I decide to harass, bully, and discriminate against. If that's the case, what you're really looking for in evidence is differential treatment. How are you treating people without disabilities better than people with disabilities? Are you allowing people with disabilities to participate in certain things that you're not allowing the people with disabilities? The most common example is access and enjoyment of community spaces. If I have an emotional support animal and there's a no pet policy in community spaces, that doesn't apply to me because my emotional support animal is not a pet. It is a prescribed tool or a companion to help me live my life equally to others. So that would be sufficient evidence to say, you're not letting me use the common space because of my emotional support animal. As far as sufficient evidence discrimination based on disability under the rules of accommodation, the key thing here is that timeline. A lot of people come to us and say, my landlord won't let me blank, build a ramp, or they won't let me lower the countertops or change the peephole on my door or something like that. And then I'll say, when did you ask them? I'll say, I don't really remember, but they know I want to. How do they know? Did you provide them a letter? Do you have a timeline? Do you have a paper trail that shows that the landlord was properly noticed that you're requesting accommodation? Because if there's no evidence that they were properly noticed, then they cannot be on the hook for violating something that they didn't know was ever a proper request. That's the biggest thing for me. So when people come to me and they don't have that timeline, I hit pause and say, we have to send a letter first. Before we can do anything, we must send a letter requesting this accommodation. Once that's received, now we wait for the denial. And if it's denied or not responded to, now we have a violation of the Fair Housing Act.
All right, Joe. And I do see that another question came in the chat, and I do see someone with their hand up. So I think first what I'll do is I'll unmute our participant who has the question that wants to be verbal, if that's okay with you.
Yeah.
Okay. Okay, Ida, you should have the ability to unmute and ask your question. Ida, I believe it's Ida. Okay, we'll remute and we'll go to the chat. Give me a second. Going into the chat, the question is, if a landlord does try and accommodate for someone's disability, but what the tenant needs costs too much or would require a lot, is it discriminatory that they are not offering any other types of accommodations that are more cost effective?
All right, I love this question. In private housing, the landlord, property manager, is allowed to say, yeah, you can do that, but you have to pay for it. And at the end of your tenancy, you have to pay to put it back the way it was. Okay, that is a fine answer. Now, if the request is going to be too much of a burden to the structure in private housing, let's say I want to take off the carpets in my floor because my wheelchair doesn't work too well with the carpets. And the landlord says, I mean, I need to say yes, but that's too much of a burden on the structure of the building. You are allowed to say, how about this alternative option? What about instead of taking out the carpets, what if we put runners, on top of the carpet or something like that? You're allowed to come up with an alternative solution to meet the need. And if it's private housing, you can say, yeah, that works as long as you pay for it. In public housing, so any sort of government subsidized housing, the landlord needs to say yes, and they have to pay for it. And that is when they're allowed to look at the cost burden. If it's an undue cost burden for public housing, they're allowed to say no, but it can't just be a straight no, period. It needs to be a no, but here's an alternative solution, because eventually we have to figure out a way to meet your need. That's the goal, meet the need, not yes or no to this particular question. And if it's a no, come back to the drawing board and ask a different question. No, there's a thing called the interactive process, and we need to figure this out together.
Awesome. Thank you, Joe. Now going back over to our participant list, I do see that Alexandra raised her hand. I'm going to unmute you or give you the ability to unmute now. Okay, you should have talking permitted and be unmuted. Alexandra, thank you for your question.
Thank you. I have a general question, well, I mean, a little bit fact-based, but basically, what if there's a group of individuals that have already been evicted in the same complex, right? They're all in the same age group, all have disabilities, and it does seem like they were targeted by a landlord, based on their disability or perhaps their age group. What would be a recommended course of action just for, finding what you need in order to try to prove a case? That makes sense. If they haven't done a good job at, keeping track of all of the dates or any letters or anything that they've received in the past.
It's a great question. So I'm constantly reminded this. I think as attorneys, we always want to do like the A to Z perfect evidence. And before we hand anything in, we've satisfied that burden of proof, preponderance of the evidence. Like we've met that high threshold. The truth is in filing complaints, that triggers an investigation. That's an administrative investigation. The investigator will then go through everything as well, contacting witnesses, gathering evidence and stuff like that. So you absolutely want to do as much as you possibly can so that you're ready to assist the investigation. But you don't have to cross a high bar threshold to simply make that complaint. So my recommendation is gather as much evidence as you can. And as long as you recognize that in the evidence you've gathered, it is, I'm going to say, a little more than plausible, maybe it's likely that this was discriminatory, that's probably enough to file that complaint, because now the investigator has some traction moving forward. Filing frivolous complaints because you're just shrugging your shoulders, maybe it's Fair Housing Act, it's not going to get you very far, because it might not even create the investigation happening. You want the investigation to be based on something. So you don't have to have the perfect paper trail, but you need at least enough evidence to say there's something going on here, and we have enough to pass it on to an investigator. In that particular scenario, my biggest question would be, of all the people who got evicted and they had disabilities, did they ever not evict someone with a disability? Like, are there still people with disabilities remaining? You always want to think devil's advocate. What is the defense going to be? And often the defense is, you're right, all the people we evicted do have disabilities, but we kept 4 families with disabilities.
Okay.
That's kind of what you're looking at.
Okay, thank you.
Yeah, of course. Great question.
All right, folks. Well, you can still add your questions into the chat or the Q&A. In the meantime, I'm going to just quickly let you all know I did post the CLE code into the chat. That CLE code is 240333, 2N as in Nancy. This is one general CLE credit. Again, if you don't write it down, if you didn't hear it or you don't see it, don't worry. You're going to get an email from Zoom within 24 hours that's going to have this recording and the CLE information. Another question came into the chat. I'll read it out loud. Sorry for bouncing back and forth. The question is, if you proceed to civil action, how much of an investigation is available? Do you do a FOIA or do you wait for discovery?
That's a good question. From my experience, and if anyone has different experience, please jump in. That investigation is kind of like, it's like this package that's accessible to you, and you get to walk into court holding this investigation that says this administrative investigation said there was a cause determination. I think there might be court rules, court procedures that the respondent party might try to make some of it inadmissible or something like that, but it's going to be a case-by-case situation. But for the most part, that investigation is supposed to be kind of that quote-unquote smoking gun that you're walking in to the courtroom with. I think each case might have a case-by-case response. My guess is it's going to depend. Yeah, I don't know if that's a good answer or not, but you're supposed to be able to use most, if not all of it.
All right, and I know that we're rounding that 1 o'clock time. Joe, Pia, do you have time for another question? I think Alexandra has another in her hand raised. You have
Yeah.
a second? Okay,
Yeah,
awesome.
of course.
Alexandra, I'm going to unmute you again. Okay, you should be able to pose your question.
Sorry, I don't have another question. I just never lowered my hand, I guess.
Okay, all right. Thank you. Well, I'll lower your hand. I appreciate it.
Thanks.
All right, and then I remute. It's always fun when we take live questions. It's a whole different technological ballgame. So, with that being said, Joe, Pia, I don't see anything else in the chat or in the Q&A, or I don't see any other hands raised. So before we close out for the day, I just want to also mention to everybody, earlier we discussed how this is part of a series, and throughout we've mentioned that this is part of a series. Just to clarify, this is going to be every Tuesday from here on out until May 28th. So this was back to basics. Next Tuesday, we have Home Suite Accessible Home. May 7th, we have Diverse Homes, Inclusive Rights, Fair Housing for Immigrants. On May 14th, we have Pride in Your Home, LGBTQ+ Fair Housing Rights. On May 21st, we have Dwelling in Safety, VAWA Rights and Fair Housing. And on May 28th, we have Fairness for Families, Fair Housing for Families with Children. So just putting that out there. Anything you want to add, Joe or Pia, before we officially sign off?
No, just a big thank you. I'm seeing all the thank yous in the chat box, and I want to thank you guys for attending and your great questions, everything like that. So we really appreciate you guys.
All right. And another last question that came in is, will participants who are not FLS employees receive the recording? Absolutely. Everyone who is here and who registered, even if you had to hop off early or hop in and out, you will all receive an email from Zoom within 24 hours automatically with a copy of the recording, the CLE information. And I think are we offering a PDF of the PowerPoint, or is that something that we're offering?
Works for me.
All right, there you go. And a PDF of the PowerPoint. Pia, anything on your end before we sign off? All right, I think you might be frozen. All right, everybody. Well, we will see you next Tuesday back here on Zoom at noon for Home Suite Accessible Home. Pia, Joe, thank you so much for everything. Pleasure to learn from you. Always honor to work with you, and I will see you next Tuesday.
Sounds great. Thank you so much. We appreciate it.
Bye.
Bye, everybody.
Thank you, everyone, for joining.